In this video, we are going to discuss how to handle sentimental items in your estate plan. Hi, I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. The first step is making a list. You have to know what it is that you care about and want to specifically give away. Because we have sort of overarching, so-and-so gets all of my personal property, or, these several people get to split it. But that doesn't account for specific sentimental items that you either want to go to specific people, or that you want to shed light on and remind that the rocking chair was built by, great-grandfather so-and-so by hand. Because you know this, but your children may not remember it when the time comes and may not understand that this is an important family heirloom. So the first thing is to make a list, know what it is that you care about, and then you have options. The first option is sort of the most permanent. We can put it directly in your will or trust. We can make a list inside the document that says, so-and-so gets the rocking chair, hand carved by such and such. Or we can say in your will or trust that there is going to be a letter included with the will or trust, and reference the statute, because here in Georgia we have a law which I think of as new, but at this point it's been around for about 3 years, that says if we reference the letter and it's found with the will, it is binding on the executor. So it used to be that we would just sort of say, hey, I have left a letter and I really hope that my executor honors it. But now you can have a letter and it can be binding on your executor. The benefit of this is that when you wake up in the middle of the night and realize that you left something off, you can add it. You don't have to come back to the attorney's office and sign a whole new will with, 2 witnesses and a notary. You can update it. Maybe, you have different pieces of property now, different family considerations, your new grandchild, you want them to have something that, 10 years ago when they didn't exist, you can't give it to somebody that doesn't exist. So that is the second option. Another option is closer to the old way of, hoping that the executor honors your wishes, but it's putting names on things. And I know this is very, very popular with families where, you put a little sticker on something and it says so-and-so's name, and then your executor knows that this person is supposed to get it. This is not binding. There is no law that says putting a sticker is binding. And I have definitely had people in my office talking about, the second wife removing stickers from things. So this one is very practical from a family standpoint because it is easy as you move through your house and as you see something and think of who would treasure it. But from a legal standpoint, it's my least favorite because it's not binding and people can sort of tamper with things. The last option is actually to give things away during your lifetime. There very well may come a point where you are downsizing, and it makes sense to pass the sentimental item on during your lifetime. And this is another way of making sure that there is a legal transfer that, of course, you can't make the person keep the item. So once it has been given as a gift to the next person, they can get rid of it, and that may be something that you don't want to happen until you have passed on and don't know about it. So there are, of course, dangers to giving items away, but this is another way of doing it legally so that no one else can step in and, disarrange your plan. So if you have personal items that you really want to think about, sentimental items, like I said, the very first step is thinking through them and making a list so that no matter which option you choose, you know what things you need to be including. if you do have an estate plan that needs to include some sentimental items, I would love to talk to you. Please give me a call. Also, thank you for watching, and please like and subscribe.